Hi Irootfornature family, and welcome to another episode of Environmental Law 101. In this video, we are going to be learning about the environmental legislative framework as it pertains to mining in South Africa. Mining is a naturally environmentally intrusive activity, and if it is not done properly, it will lead to irreversible harm on the environment, pollution, loss of lives. Mining also uses a lot of water, therefore it poses a risk to the quantity and quality of our water resources, which are already scarce and in need of protection. As a result of all of this, and in order to ensure sustainable development, it is therefore imperative that mining activities are properly managed and regulated, and that mining companies actually comply with the law. This will protect people's lives by ensuring that their rights to a healthy environment is safeguarded. It will also protect the environment because then we are actually able to avoid, to prevent, or to mitigate any environmental harm caused by mining. When it comes to the legislative framework in relation to mining, the starting point is always Section 24 of the Constitution. All mining activities have to be conducted in a sustainable manner and has to respect and uphold the environmental right. I'm not going to go into detail on this right here because I've already done a video on that. So please go and have a look at episode 1 of Environmental Law 101 for an in-depth analysis of the environmental right and Section 24 of the Constitution. The MPRDA is the main piece of legislation regulating and governing mining and the production of petroleum resources in South Africa. The MPRDA itself acknowledges the negative impacts of mining on the environment, and thus one of its main objectives is actually to uphold the environmental right and ensure the sustainable use of mineral resources. As such, the MPRDA is also subject to NEMA, the main legislation regulating environmental management in South Africa. Here, I suggest that you go and watch episode 2 of Environmental Law 101 for an in-depth analysis of NEMA. As mentioned, mining is regulated under the MPRDA. In terms of Section 16, 22, 27, 80, and 81 of the MPRDA, an environmental authorization is required before one can engage in prospecting, extraction of mineral resources, and the exploration and production of petroleum resources. An environmental authorization, in short EA, is granted in terms of Section 24 of NEMA, and a range of factors have to be considered before it is granted. And this includes whether or not an activity, in this case mining, will lead to unacceptable environmental degradation and pollution of the environment. I deal with this substantively in episode 2 of Environmental Law 101, so please go and have a look at that. I now pause here to clarify the licenses that are required as well as the competent authorities in relation to mining in South Africa. Before you start mining, certain licenses are required. You're going to need a mining right or a mining permit or a production right if you're going to be embarking on petroleum extraction. For the purposes of this video, I'm going to be sticking to mining and a mining right. However, the requirements for all these licenses are either the same or similar depending on what you want to do and what the MPRDA actually says about that. A mining right is regulated under Section 22 through to Section 24 of the MPRDA. In terms of the MPRDA, when you apply for a mining right, you also have to simultaneously apply for an environmental authorization. These two are essential licenses that are required before you commence with any mining activities or mining related activities. Otherwise, your conduct is unlawful. The Minister of Mineral Resources, through the Department of Mineral Resources and Energy, DMRE, is responsible for the issuing of mining rights. Please note that even though environmental authorizations are regulated under Section 24 of NEMA, and in terms of Section 24 of NEMA, it is the Minister of Environmental Affairs who is the competent authority for all environmental issues, when it comes to mining, the law is different. An environmental authorization for mining activities and mining related activities is issued by the Department of Mineral Resources. Therefore, the Minister of Mineral Resources is actually the competent authority when you are applying for an environmental authorization. However, when it comes to an appeal against that environmental authorization, that appeal goes to the Minister of Environmental Affairs. The question of whether or not this mandate is properly placed is a debate that is currently ongoing, and different people have different viewpoints on it, but I am not going to go into detail with it right now. The main issue here is that the Department of Mineral Resources and the Minerals Minister, on the one hand, they have the mandate to promote mining and mineral extraction in South Africa. And on the other hand, they've now been given this mandate to ensure that mining is done in a sustainable way because we want to reduce the environmental damage it has. These two are actually conflicting mandates because you cannot really promote mining but on the other hand bring it down based on environmental grounds. And at the same time, there's a conflict where you now have to say no to this mandate you have to promote mining as a result of environmental issues, right? So it's always conflicting, and oftentimes we find that the department may end up promoting mining more than it actually promotes sustainability. So that's where the issue lies in. There are different viewpoints on this, but I'm not going to be dwelling on it. But I just need you to be aware of it, that when it comes to mining and the environment, these are some of the conflicting and controversial issues that are happening in the field, and that still needs to be resolved. Also, another factor when it comes to mining is that it uses a lot of water. Mining uses a lot of water in terms of the activity itself, the amount of water it needs, but at the same time, it has a detrimental impact on water resources, especially when it comes to acid mine drainage. So it can lead to the contamination of water resources, and therefore that means that we have to regulate how water is used in relation to mining. As a result of this, a water use license is required before you can embark on any mining activities. This license is regulated under the National Water Act, and the competent authority for it is the Minister of Water and Sanitation through the Department of Water and Sanitation. The DWS is responsible for applications and the issuing of water use licenses. Now, if you want to appeal a water use license decision or anything related to a water use license, that appeal does not go to the Minister of Water and Sanitation. Instead, it goes to what is known as the Water Tribunal. This is a statutory body that was created in terms of Section 148 of the National Water Act. So you have to go through the processes that are listed under Section 148 in order to bring your appeal to the Water Tribunal. One important thing to note here is that the arrangement that I just described here and the different competences are established under what is known as the One Environmental System. The One Environmental System was established in December 2014 to streamline the environmental processes for mining, environmental authorization, and water use. This came about because it was not really clear who the competent authorities were, and also it was taking a little bit long for certain licenses to come out, and it was delaying projects and people are not so sure. So in order to promote integrated environmental decision-making processes, they came up with the One Environmental System. There are also other licenses and approvals that are required before you commence with mining activities. For instance, a rezoning approval. Where land that one intends to mine on is not zoned for mining, one has to apply for a rezoning approval, which will permit mining on that land. So for example, if you want to mine on land that is currently zoned for agriculture, you cannot just go on and proceed with mining there. You actually have to apply for a rezoning approval that allows that mining to take place. So it essentially changes the zoning of that land from agriculture to mining. If you do not get that, your mining activities are unlawful. The rezoning approval is applied for in terms of SPLUMA, that is the Special Planning Land Use Management Act, and the competent authority for this is the local municipality in the region or the district that you intend to mine. Any appeals on the rezoning approval have to go to either the municipal tribunal or the municipal appeal authorities of those municipalities before you escalate, of course. Another approval that is required is an environmental management plan or an environmental management program. An environmental management plan is regulated under NEMA. An environmental management program was regulated under the MPRDA. I'm going to explain a little bit later the differences between those two and why each is regulated differently. So this application is usually submitted when one submits an application for a mining right. And although it works hand in hand with the environmental authorization and environmental impact assessment processes, it is not an environmental authorization. An environmental authorization, on the one hand, it authorizes certain listed activities that will have a detrimental impact on the environment. And an EMP or an EMPR, it looks at how to manage those impacts in order to either prevent or avoid or mitigate the harm caused by those activities throughout the life cycle of that mine. It is important to note here that there is some kind of a distinction between the regulation of mining prior to December 2014 and after December 2014. Before December 2014, the one environmental system was not in place. This means that in terms of NEMA, mining itself was not a listed activity. However, there were certain activities that were related to mining that were listed activities and therefore required an environmental authorization. If you're going to be mining prior to December 2014, a lot of companies did not apply for environmental authorizations because mining itself was not a listed activity under NEMA. However, they had to get an EMPR, which is an environmental management program that was approved and granted under the MPRDA. This EMPR therefore managed all the environmental impacts that would occur as a result of your mining activity. Now, there has been some conflict around this arrangement, and this conflict arises by virtue of the fact that a lot of mining companies, they believe that if you started mining prior to December 2014, and bear in mind that some of those mining companies are still in existence and they're still mining and they hold those kind of authorizations that were granted prior to December 2014, right? So you can't ignore that. So if they are of the view that the EMPR that was granted prior to December 2014 was enough and sufficient and it covered the field. This means that post the one environmental system, that EMPR has now been deemed as an EA that is granted under NEMA. However, these two things are very different if you actually look at them, and that's where the conflict arises. Another part of this conflict is that it is not actually believed by a lot of mining companies that an environmental authorization was required for mining related activities prior to December 2014. So a lot of conflict is a reason here. Personally, I think that that is flawed because in as much as mining itself was not a listed activity in terms of NEMA, there are other mining related activities, that is activities that you have to do in order for you to mine that were actually listed activities in terms of NEMA and required an environmental authorizations. These activities are things that range from the building of roads, construction of buildings on the mining side, clearing of vegetation, fencing, and all of that. So those related environmental authorizations. So therefore, the EMPR, which was about managing environmental impacts, cannot cover the impacts of these things. Those things needed to be authorized. This is a debate that is ongoing. There are a lot of people who are also of this view and certain courts that are on this view. However, it is very important for you to know that even our courts are divided on this aspect, so it is not so clear what the law exactly is or was when it comes to mining and environmental authorizations prior to December 2014. So basically, this is where the law gets murky. The Constitutional Court had an opportunity to decide on this recently, but they did not venture into that. So therefore, it is still a very murky part of the law. But it's also important for you to know, because if you are going to be fighting a mine or appealing decisions or whatever about a mining activity, it's important to know when that mining was authorized. Because if it was authorized pre-December 2014, the law can be a little bit trickier than, say, if it was authorized post December 2014. So that's why I'm pointing out this to you right now, so that when you are facing a mining challenge, you kind of have to know that your starting point is to find out when the mining activity was authorized, because that determines how you're going to approach the rest of the matter. The intersection between mining and the environment is a very exciting one and controversial too. It is such a broad topic, and I don't think I'm going to do any justice on it in a 10-minute video. So this is part 1 of a series on mining and the environment that I'm going to be doing in the next coming weeks. I'm so excited for the series, and I hope you guys have also started to get your heads around mining and the environment and some of the conflicting issues around it that are also very exciting for me personally. I hope you find this video as a useful introduction to mining and the environment and the legislative framework, as well as some of the controversies around it. Alright you guys, this is the end of this video. Please leave a comment or any questions or video suggestions that you have down below. And don't forget to like and share this video with others so that we can learn together. If you have not subscribed yet, please do subscribe and join the family for more videos like this. And until the next time, stay true, keep fighting, and keep the earth clean.